Hey besties! So Blake Lively's attorneys waited until literally the end of the court day to finally address the missing audio recording. This is the same audio Blake claims contains statements by Steve Sarowitz threatening to spend $100 million to destroy her, and the audio allegedly recorded by Claire Aubie without Steve's consent during Empire Waste. This recording was never actually filed with the court. Blake's team referenced it in their motion months ago, but no copy was ever provided to the clerk or the judge. That means no one, not the judge, not the court, not the public, has ever heard it. Earlier this week, the judge noticed this and basically said, "If you're going to reference this audio, where is it?" The public is now requesting it. Provide it or tell us your plan. Blake's lawyers filed a letter today saying they will finally give the clerk a physical CD copy, which the clerk will then duplicate and distribute to the public on request. They say the docket system can't technically accommodate uploading the file. But here's the problem. If they had just provided the CD when they filed the motion, none of this mess would exist. And it still doesn't explain how the judge was supposed to evaluate an audio exhibit he never actually received. Now, normally when you submit an audio recording into federal court, you must provide authentication, a sworn chain of custody, how it was recorded, who recorded it, that it hasn't been tampered with, a transcript. None of that has been done yet. Right now, this audio isn't evidence. It's just an unverified exhibit. The court hasn't ruled it admissible. It hasn't been authenticated. It could still end up excluded at trial. Even Claire's declaration doesn't meet standard authentication requirements. She never says how she recorded it. Phone, Zoom, memo app, hidden device, nothing. So even if the public hears it, there's no guarantee it will ever be allowed in front of a jury. Another twist. Wayfarer isn't fighting the release, which is interesting, because if the audio were fabricated, they would be aggressively blocking it. The fact they're saying, "Go ahead and release it," suggests they're confident. Finally, the judge also issued overlapping rulings tied to the New York Times dismissal. The Times wants final judgment so they can be fully discharged from the case, but the judge says the case still isn't technically closed because there are outstanding fee motions. Until those are resolved, the dismissal can't be finalized. So in short, the audio will be released via CD. It is not authenticated as evidence. It may never be admitted at trial. Major procedural questions still unresolved. One of the most confusing parts of this is why Blake's attorneys didn't simply follow standard procedure. If you're going to claim that this audio proves a threat campaign, then you have to actually give it to the court and authenticate it. Without that, it's basically just hearsay attached to a filing. And this is why legal analysts are saying it looks more like a PR tool than a legal strategy. Because if you genuinely intended to use this as evidence at trial, you would have followed the process correctly the first time. Another big question here is why a CD? In 2025, every federal court accepts digital uploads, MP3, WAV, MP4, all of it. So the excuse that the docket cannot technically accommodate an upload raises eyebrows. The only time CDs are typically used is when a party wants to delay review and complicate public access. If this audio was as explosive and damaging as Blake claims, they'd be rushing to authenticate it, not slow-rolling it. And remember, even once the public hears it, that doesn't mean the judge will allow it in. Before it can be admitted in court, there has to be a clear timeline of who possessed the recording, how it was stored, whether it could have been edited, a sworn statement from the recorder explaining the method, a transcript, and a legality ruling on consent. Until those steps happen, this is just an exhibit being used in a motion, not evidence for trial. Meanwhile, the judge is also dealing with the parallel issue involving the New York Times. The Times wants a final ruling so they can exit the case completely, but the judge said the case is still open because fee-related motions are unresolved. In other words, the Times has been dismissed, but not fully discharged yet. Because the overall case is still active, he also made it clear that the Times misunderstood the procedure. The consolidation of the two cases did not mean a final judgment waits until everything in both is finished. So now the court is basically forcing every party to confirm what motions are still open so the judge can rule on whether the Times can officially walk away. This is important because all of these loose procedural ends are part of the reason this case continues to drag out, and why Blake's team keeps getting accused of weaponizing delay. The timing is what's getting the most side-eye from legal watchers. Blake's attorneys waited until the very last minute of the court day to notify anyone about their decision on the audio, after ignoring the court's request for days. That kind of move signals hesitation, not confidence. If this recording truly supported Blake's claims, her team would have been waving it around from day one, not hiding it until they were directly called out by the judge. And that's the key issue here. It wasn't Wayfair that pointed this out. It was the court itself noticing that the audio was missing. Judges do not like being misled. They expect that if a filing tells the court Exhibit A, audio recording, the audio exists inside the filing or at least with the clerk. Instead, the court had nothing. Not the judge, not the clerk, not opposing counsel. That is exactly why credibility is now on the table. Because the moment it looks like a party has withheld evidence, intentionally or by accident, every other piece of evidence they submit becomes suspect. The judge may now require additional verification on anything Blake's team files going forward, which means more friction, more delay, and more scrutiny. And there's another layer. This raises a consent problem. If this was secretly recorded, and if Steve didn't know he was being recorded, and if California law requires two-party consent, then Blake may have been sitting on an illegally obtained recording this entire time. If the judge determines it was recorded unlawfully, not only can it be thrown out, but it can hurt Blake's case more than it helps it. So instead of this becoming the smoking gun that Blake hinted it was, it may become Exhibit A in why her motion fails altogether. Wayfair's response, agreeing immediately to release the audio, is also telling. If they believed this audio was damaging, they would be fighting it. Instead, they're basically saying, go ahead, put it out. We have nothing to hide. That suggests they believe the content either doesn't say what Blake claims, or it's so out of context that once the full recording is heard, the narrative collapses. And that's exactly why this next phase, the clerk releasing copies, is going to be a turning point. If the audio doesn't match the claims Blake made in her filings, the court could view this as an attempted misrepresentation. And judges do issue sanctions for that. Rule 42 does not give Blake the protection her team seems to think it does. Consolidation of cases does not erase their separate legal identities, and the Supreme Court has been very clear that even when matters are consolidated, a final decision in one is still immediately appealable. That means the New York Times can argue that their dismissal should already function as a final judgment. But the judge is asking all parties to show cause and clarify whether the outstanding motions for fees prevent the case from being formally closed. If the fees issue is considered still live, then the Times may have to wait. If not, the judge could discharge them sooner. Each party now has to explain whether they believe the case is still technically open because of unresolved fee disputes or whether finality has already attached. Meanwhile, circling back to the audio disc, the judge set a hard deadline. Blake must provide a physical copy of the CD to the court by October 20th, 2025. That means she has until Monday to finally hand it over. The strangeness here is not that the judge is requiring a CD. Courts do occasionally accept physical media, but that Blake's team failed to provide it at the time they originally filed the motion. If the exhibit was central to their argument for sanctions and punitive damages, it should have been filed alongside the brief. Instead, for months, the court has had references to an audio that no one, including the judge, had actually heard. The way Blake's team is now choosing to provide the audio also raises accessibility issues. They are delivering a physical CD to the clerk, who will then make copies for members of the public who request it in person. That means anyone wanting to hear it must either physically go to the courthouse or request a mailed copy, and then also have a CD player, something many people don't even own anymore. Typically, courts accept digital submissions through electronic docketing in standard formats like MP3, MP4, or WAV, which can be accessed remotely. So there is no legal or technical barrier preventing Blake's team from uploading a digital version. It is simply their choice not to. That decision creates a delay, and more importantly, distance. The slower and more cumbersome the access method, the fewer people will hear the recording immediately. It also leaves room for speculation on whether they feared distributing it themselves, because of potential legal implications tied to how the recording was obtained. If there are ongoing questions about consent, chain of custody, or authenticity, they may prefer that the court, not them, be the entity that makes it public. By funneling access through the clerk, distribution is no longer their direct action, which could be a way of insulating themselves if the recording ultimately triggers a dispute over whether it was obtained lawfully. Realistically, access will still happen. Someone local, a journalist, Reddit user, or watchdog, will almost certainly go to the courthouse early next week, request a copy, and upload it online. But the path Blake's attorneys have chosen suggests caution, not confidence. If they believe this audio was a decisive blow in their favor, They could have released it electronically weeks ago, linked it publicly, and controlled the narrative. Instead, they waited until they were forced by the court to take action, and even then opted for the least direct method available. The delay only invites more questions about what the recording actually contains. It raises a major red flag that this recording was not handed over to the court at the same time the motion was filed. Normally, when a party submits a motion and claims there is supporting evidence, that evidence is filed alongside it, not weeks later, not separately, and certainly not withheld under the excuse of being under seal. Courts cannot rely on documents they don't have, and a judge cannot weigh evidence that was never properly submitted into the record. When someone files a sealed exhibit, it still goes to the court the same day. It is simply marked under seal, not withheld entirely. So the delay immediately creates the impression that this motion had more of a public relations intention than a legal one. Because if the goal truly was a legitimate legal move, the evidence would have been there from day one, already in the judge's hands. There's also a misconception people sometimes have about discovery. Judges do not automatically receive access to the discovery materials exchanged between the parties. Discovery happens behind the scenes, between attorneys. The court only sees the pieces that are formally submitted as evidence through motions and hearings. Unless something is filed into the court record, the judge doesn't review it, doesn't listen to it, and cannot consider it. And because this audio was categorized under attorney's eyes only, even the opposing parties themselves couldn't review it. If it stayed sealed this entire time, then neither Sarowitz nor Belon nor anyone else named in the dispute actually heard it. It remained effectively invisible to everyone except lawyers, and even then, it's not guaranteed they received a usable copy yet. Technically, until it is logged into the court system as an actual exhibit, it's still functionally sealed. No judge, no clerks, no opposing counsel, no defendants. So all anyone could do during that period was speculate. The fact that the evidence arrived in the form of a CD in 2025 only adds to the oddity. It's not that CD filings are illegal, they're just deliberately inconvenient. If someone wanted to make public access harder or slower, submitting physical media instead of a simple digital upload is a perfect way to delay everything. And whether that delay is strategic or accidental, it still shapes how the process plays out. By Monday, the audio will finally be in the court's physical possession, and once it is retrieved and uploaded by whoever first gets access. Reportedly, a Reddit user named Clark plans to go in person the moment it becomes available. The public will finally be able to hear what's actually on it. Only at that point will there be any clarity about whether the recording supports the claim being made, namely that there was a coordinated conspiracy to undermine and silence her. Until then, it is impossible to know if it's a legitimate piece of corroboration or just another procedural filing designed for optics rather than substance. Once the audio is publicly accessible, the real test will be whether it actually carries legal weight, whether it's admissible at trial, whether it aligns with the broader claims being made, and whether it meets the evidentiary threshold of helping the court reach a real conclusion. Until then, this remains a pending piece of alleged proof, not verified evidence. Now, this delay also highlights another important dynamic within high-profile civil litigation: the difference between legal strategy and public narrative strategy. When a filing is timed in a way that generates headlines before the actual evidence appears in the record, it suggests the public messaging may be prioritized over the courtroom outcome. This isn't illegal, but it is very telling. A party that is confident in its proof normally rushes to get it in front of the judge as fast as possible. A party more focused on optics tends to release claims first and evidence later, after the media cycle has already been shaped. That is why observers are questioning the intent here. If the audio was truly as explosive as it is being described, it would have been attached immediately to maximize legal credibility. Instead, the delay ends up softening its legal impact and strengthening the argument that it was used as leverage in the court of public opinion rather than the court of law. Legally, late evidence introduces another complication. The opposing party is given grounds to argue procedural irregularity, which means even if the audio contains something meaningful, they could still challenge how and when it was submitted. Courts don't just care about what is filed, they care about how it is filed. Chain of custody, timing, accessibility, filing procedure, and disclosure rules all matter. And as of now, the chain of custody is extremely unclear. We still don't know who had possession of the original recording, who stored it, when it was transferred, or whether a true authenticated master version exists. Before anything gets admitted, that has to be proven. A court will not rely on an unidentified disk with an unverified origin story. On top of this, even once made public, the audio still has to pass an evidentiary test later known as admissibility. That means it must be authentic. The court must be satisfied that the recording is real and unaltered. It must be relevant. It can't just be sensational. It has to materially connect to a legal claim. It must meet procedural handling requirements. Anything submitted incorrectly can be excluded before trial. So even after the public hears it, its legal value may still be contested. The content alone does not automatically guarantee it ever sees the inside of a courtroom. For now, everything hinges on what is actually captured in the recording. If it merely contains speculation, commentary, or hearsay, even dramatic-sounding statements, it may not meaningfully support the conspiracy claim. On the other hand, if it captures a direct discussion about intentionally undermining her or coordinating reputational damage, then the case shifts dramatically. That's why the anticipation is so high. People are trying to determine whether this is a turning point or just another procedural stunt. And the gap between filing the motion and supplying the recording has created more doubt than certainty. Once the court officially logs the CD, only then does the next stage begin: authentication, transcript requests, legal challenges, and admissibility review. And this is where the timing matters even more than people realize. Because once something becomes part of the official court record, the narrative control shifts away from the party making the claims. Before evidence is filed, it's easy to shape public perception because nobody can independently verify what's being alleged. After filing, however, the public, the press, legal analysts, and ultimately the judge can examine it directly. In other words, the moment the CD becomes part of the docket, the speculation phase ends and the accountability phase begins. That is also why critics are now wondering whether the delay was intentional, not for legal reasons, but for narrative cushioning. If you build suspense before evidence appears, the public is emotionally invested before they intellectually evaluate the substance. From a PR perspective, anticipation is a tool. From a legal perspective, it's a liability. There's also another layer here: the attorney's eyes-only designation. This is the most restrictive form of confidentiality in civil litigation. It doesn't just keep the public out, it keeps the parties themselves out. Only the lawyers get access. That means if the recording was filed that way initially, the defendants themselves could not hear it, respond to it, or prepare rebuttal arguments. That can be strategic in two ways: weaponization through secrecy, by implying there is damaging material while preventing the other side from reviewing it, or stalling, by filing something that sounds powerful without actually introducing it into active litigation until much later. But again, all of that leverage evaporates once the court has it. The minute it is officially submitted, the next procedural step is transcription, public review, and litigation scrutiny. And then we reach what will likely be the turning point in this entire dispute: whether the contents of the recording are actually probative or merely performative. If the recording documents planning, coordination, reputation sabotage, or intentional interference, then it opens the door to claims of malice, conspiracy, and reputational torts, and which are extremely serious. But if the audio turns out to be speculation, venting, hearsay, or third-party commentary, then it collapses under its own weight and ultimately strengthens the opposing side, because it exposes the filing as theatrics rather than evidence. And that's the risk of this kind of legal tactic. A dramatic buildup with a weak payoff doesn't just fall flat, it backfires. Courts do not look kindly on theatrics packaged as evidence. Judges are particularly sensitive to anything that appears to be leveraging public sympathy over procedural legitimacy. So Monday is not just about a disc being handed over. It's the transition from storytelling to scrutiny. It's the moment this case stops being theoretical and becomes evidentiary. And once that door opens, it cannot be closed again. Either way, the release of this audio is going to be a turning point in this case, one way or another. Let me know your thoughts in the comments. Do you think this recording is going to live up to the hype, or is this another PR push disguised as a legal move? If you found this breakdown helpful, make sure to hit the like button, subscribe, and turn on notifications so you don't miss the follow-up once the audio becomes public. Thanks so much for watching, and I'll see you in the next one.